Great, thank you. Great, so as mentioned, I'm presenting this on behalf of the Endangered Wildlife Trust, and it's really in line with our increasing research in terms of wildlife welfare. And essentially what we'll show here is an increase in recognition from our courts in terms of the concept of animal welfare. And I suppose the benefit or maybe disadvantage of going third is that a lot of the content has at least been introduced by my colleagues, and we'll just look at some of the court cases in a little bit more detail. So, jumping right in, this is a statement from the 2018 report that the Endangered Wildlife Trust and the Centre for Environmental Rights published through funding from the Lewis Foundation, where it was stated that captive wild animals, whether held temporarily or permanently, uncomfortably straddle the divide between the interdepartmental and concurrent national and provincial jurisdiction, due to a regime that is unintended and unsuited to addressing wild animal welfare. In fact, wildlife welfare is generally understood to be almost non-existent and merely incidental to conservation in some instances. Now, in light of the statement, what we'll look at in the course of this presentation is the increased recognition by our courts to welfare needs of animals specifically, but also a broader recognition of wildlife welfare. And we'll also look at some developments in other spheres of governance, including, well, also looking at other departments. And then we'll finally conclude this presentation by looking at proposed amendments to the National Environmental Management Biodiversity Act, where proposed amendments are to include the term well-being into the provisions of the Act, and we'll then assess whether well-being actually goes far enough or not. I would also just like to note a referencing mishap that led to an error in our abstract for those who have been able to read it. The judgment or the statements that were quoted were actually from Justice Kempepe from the National Society for Prevention of Cruelty to Animals versus Minister of Justice and Constitutional Development. I had abbreviated that court case to NSPCA 2016 in our research, and that then got confused with the NSPCA 2020 case. So my sincere apologies for that. As I mentioned, in 2018, we published a report with the CER through funding from the Lewis Foundation to look at wildlife welfare in South Africa. And as part of that report, we highlighted several concerns regarding the regulation of wildlife welfare. The report itself is divided into three parts. The first is an evaluation of the legal framework. The second then considers the practical application of the legal framework. And then the report concludes in part 3 with providing legal and practical recommendations. If we consider the legislative setting for wildlife regulation in South Africa broadly, it's a complex area with several different departments at national and provincial levels operating within the space, but it's also saturated with a wide array of legislation applicable to wild animals in general, some of which include welfare provisions, or at least provisions to prevent harm to those wild animals, and some don't. South Africa's primary animal welfare statute is the Animals Protection Act, which aims to prevent unnecessary cruelty rather than promote the care and welfare of animals. Now, there are several weaknesses with the Animals Protection Act generally, but there are also noticeable challenges in terms of its implementation, as well as legitimate concerns towards the, sorry, I see something's coming through on the chat, towards the, I just want to make sure that everything is okay, towards the suitability of wild animal protection generally. The Fair Game report also found that traditionally, or at least for the last 30 or so years, matters of animal welfare have been regarded as falling under the Department of Agriculture, and then also that animal welfare is not generally regarded as a consideration in environmental protection, partially because it's perceived to be an exclusive categorization of an agricultural concern, and partially because it's not generally believed to be relevant for biodiversity and conservation. And I'm very glad that I can show case law now that is disputing and actually finding against that position. So there's some nice developments there in terms of our jurisprudence. So looking now at what our courts have held in terms of wildlife welfare, the first case we'll consider is the NSPCA case versus Openshaw from 2008, where the NSPCA appealed the decision of the Bloemfontein High Court, which dismissed the application, or their initial application for an interim interdict. And what they were trying to interdict was Openshaw giving live prey or animals to the tigers in his care. The NSPCA holding that contravened the Animals Protection Act. Now, the majority judgment dismissed the appeal with costs, but Cameron, in his minority judgment, took a dissenting view, holding that the interdict should have actually been granted because it was a violation of Section 2G of the Animals Protection Act, which prohibits, the exact wording from the Act is the liberation, or I suppose one can replace that with release, of any animal in a manner or place so as to expose it to immediate attack or the danger of attack. And it's very clear that releasing animals into an enclosure with tigers clearly contravenes that section. But the reason I noted this judgment and wanted to raise it today is that Cameron also added the following statement, and I think it starts the timeline really of increasing recognition of our courts towards animal welfare. And he stated that the statutes recognize that animals are sentient beings that are capable of suffering and of experiencing pain. And they recognize that regrettably humans are capable of inflicting suffering on animals and causing them pain. And the statutes thus acknowledge the need for animals to be protected from human ill treatment. The next case to consider is the Sarpa litigation against the Minister of Environmental Affairs, where in this case, Sarpa, along with other applicants, challenged the validity of regulations included in the TOPS regulations when they were first promulgated. And they specifically challenged the provisions that prevented lions from being hunted within a period of 24 months, from being released as a put and take animal. And put and take animal means that a specimen of what is defined as a captive red large breed predator, or one of the rhino species, white or black, that is released for the purpose of hunting the animal within a period of 24 months after its release from the captive environment. Now, the High Court dismissed the application, finding, and this is a quote from the judgment, that the hunting of lions bred in captivity has damaged the reputation of the Republic of South Africa immensely. It is clear in the evidence, and also not disputed, that very many people all over the world find the notion of hunting a lion bred and raised in captivity, often by hand, to be totally, often by hand, and totally dependent on humans for its survival, abhorrent and repulsive. Unfortunately, when this matter was taken on appeal, it was successful in part, and the court declared that the inclusion of lions as a definition of illicit large predator invalid insofar as it applies to put and take animals. The next case to consider is the Lemtong Thai case, and in this matter, Lemtong Thai was convicted on several contraventions in terms of the Customs and Excise Act and the NEMBA. And what the Supreme Court of Appeal found here is that the constitutional values dictate a more caring attitude towards fellow humans and animals in the environment in general. Looking now at the NSPCA case versus Minister of Justice and Constitutional Development that has been addressed by Melanie as well as David and Michaela. In this matter, the NSPCA brought a constitutional challenge to determine whether it was entitled to privately prosecute crimes of animal cruelty. And the basis for this was a religious sacrificial slaughter of 2 camels that involved several attempts to sacrifice the camels through slicing their throats. And ultimately, through several botched attempts, the NSPCA official actually had to step in and shoot the camels. The NPA in this matter declined to prosecute, and the NSPCA sought to institute private prosecution. And the case then turned around whether the NSPCA was authorized, or at least it was permissible in terms of Section 7 and 8 of the Criminal Procedure Act to privately prosecute. Now, the Constitutional Court on the matter of animal cruelty looked at the history of South Africa regulating against cruelty to animals and found that it dates back to 1914. and then made several references to cases. And one case I've highlighted just in particular to kind of show the progression of our courts in terms of their attitude towards wildlife, animals and their welfare. There was a case in 1947 where it was stated that the legislation was developed to promote animal protection, to prohibit one legal subject behaving so cruelly towards animals that he offends the finest feelings and sensibilities of his fellow humans. Now, when one compares this to the statement by Cameron that the statutes recognize that animals are sentient beings that are capable of suffering and experiencing pain, we can see a very clear progression. And this progression was then noted in the courts, where they found that we've moved from the mere safeguarding of the moral status of people to placing an intrinsic value on wild animals as individuals. The Constitutional Court in this matter also found that the Lemtong Thai case was notable for several reasons, but that it links animal welfare to questions of biodiversity, and as has been raised in the previous presentations, found that animal welfare is connected with the constitutional right to have the environment protected through legislative and other means, and that this integrative approach, which links to David's presentation, correctly links the suffering of individual animals to the conservation in general, and illustrates the extent to which showing respect and concern for individual animals reinforces broader environmental protection efforts. And that animal welfare and animal conservation together reflect entwined values. In the final case to look at is the NSPCA case versus Minister of Environmental Affairs, and in this case the NSPCA instituted review proceedings seeking to set aside the quotas that were established for 2017 and 2018 for lion bone exports. And the basis for this case is that the Minister of Environmental Affairs did not take into account the welfare of lions in captivity, which the NSPCA held to be a relevant consideration. The Minister, in her response, argued that the national department responsible for the environment has no legislative mandate in terms of regulating on welfare matters, and that, and that considerations of welfare were not deemed scientific or relevant to the determination of the annual quota. Now, the court held that it was correct that the welfare mandate rests with the Department of Agriculture, but that it was incorrect to state that because you don't have a welfare mandate, you don't have to take welfare considerations into account. The court also held that the welfare of captive lions is a matter of public concern, inextricably linked to how we instill respect for animals and the environment, of which lions in captivity are an integral part. They also mentioned or confirmed that captive lions still form part of biodiversity, and this is very important given recent amendments, including the Animal Improvement Act that was mentioned earlier. And then finally, in assessing the failure to take welfare considerations into account, the court held that it was illogical, irrational, and against the spirit of Section 24, and how our courts have included animal welfare concerns in the interpretation of Section 24. The court said that, simply put, if as a country we have decided to engage in trade in lion bone, which it appears to be the case for now, then at the very least our constitutional and legal obligations that arise from Section 24 and NEMBA require the consideration of animal welfare issues. Looking very briefly at the increased recognition of animal welfare in other spheres of government, Parliament published a report in 2018 following its colloquium that was held in August, and apologies for the typo on the screen where August is lowercase, but it included the following recommendations: that the Department for Environmental Affairs initiate a policy and legislative review of the captive breeding of lions and the captive breeding of lions for hunting, and the lion bone trade with a view to putting an end to the practice. And that the Department of Environmental Affairs, now the Department of Environment, Forestry and Fisheries, and the Department of Agriculture, Forestry and Fisheries, now the Department of Agriculture, Land Reform and Rural Development, present a clear program of work on how they intend to address animal welfare and health concerns. The Department for Agriculture has also noted that they're publishing draft norms and standards for the welfare of captive lions, and here I would argue that that doesn't really go far enough. It's not just about captive lions, but all animals in captivity, and we do need increased recognition from the department. But focusing now on amendments to our conservation legislation, in 2017, several amendments to NEMBA were included in the National Environmental Management Laws Amendment Bill to empower the Minister to regulate on the well-being of wildlife. And these amendments include defining well-being as defined as a state where living conditions for fauna or biological resources are conducive to its health. And this is found to be troublesome for several reasons. One, it's incredibly narrow in its approach, and it limits well-being to health. Two, the scope of health is uncertain, and we're unclear if it would include psychological or psychosocial concerns as well. And three, the terms health and well-being themselves are mutually exclusive terms, as is illustrated in our Constitution, and shouldn't be combined interchangeably as proposed in the definition here. So we would urge that the definition of well-being be replaced with welfare, and this amendment carried throughout the proposed amendments to NEMBA. We also recognize that animal welfare considerations vary from species to species, but is really reflective in how the individual of a species is coping with the conditions in which it lives. And they take guidance from the American Veterinary Medical Association, which provides that an animal is in good state of welfare, as is indicated by scientific evidence, if it's healthy, comfortable, well-nourished, safe, and able to express innate behavior, and if it is not suffering from unpleasant states such as pain and distress. Now, the other amendments that come through essentially include well-being in the considerations in terms of our objectives of NEMBA, linked to ecological sustainability, and also allowing the Minister to make regulations and prohibitions based on the well-being of species. And in conclusion, looking at what more opportunities we have to strengthen wildlife welfare in South Africa, and this could be legal amendment more broadly. Several options and opportunities were discussed in the report that I mentioned earlier. Standardizing the permitting system and making that more transparent, so bringing in considerations, for example, as to whether people can actually look after the animals for which they're getting conservation-related permits for. And then finally, investment in compliance and monitoring, as well as enforcement capacity. So with that, it brings our presentation to an end. Thank you very much.